I'm Drew Stevenson, and this is a lecture for my professional responsibility class about ABA Model Rule 8.5, Disciplinary Authority and Choice of Law. Now, what we're going to be talking about in this rule is which states' ethics rules or disciplinary rules apply when you commit a legal violation. So here's section A of 8.5. A lawyer admitted to practice in this jurisdiction is subject to the disciplinary authority of this jurisdiction, regardless of where the lawyer's conduct occurs. So what does that mean? That means that if you commit a violation, let's say you're admitted in Texas and you handle a case in California under, let's say, pro hoc vici admission, that Texas could still discipline you for violations that you commit out of state. 8.5 continues, a lawyer not admitted in this jurisdiction is also subject to the disciplinary authority of this jurisdiction if the lawyer provides or offers to provide any legal services in this jurisdiction. Now, quick aside for my students, Texas does not follow this provision of the rule. This position of this Texas State Bar is that they only have jurisdiction over lawyers licensed to practice here. But for purposes of the MPRE and my exam, this is the rule that you need to learn, the ABA model rule. And this means that lawyers admitted in another state who come to Texas to do some legal work, and it could be something that they're not authorized to do at all, or it could be something that they're allowed to do, like a pro hoc vici appearance, or to settle up an estate for a client in their home state. If they commit a violation here, they're subject to discipline in this state. Notice what this means. This means that you could be subject to discipline by two states at once if you commit a violation, if you cross state lines, your home state where you're licensed and the state where the violation occurs if you've gone out of state and then you violate the ethical rules. Okay, 8.5 continues, a lawyer may be subject to the disciplinary authority of both this jurisdiction and another jurisdiction for the same conduct. So we're not going to have any double jeopardy concerns because we're not sending you to jail. This is an administrative matter about licensing and maybe suspending your license or giving you a reprimand or possibly disbarring you, and because we're going to subject you to discipline. But please notice that you could have a grievance that you have to deal with in more than one state over the same incident or the same violation. And this is why we have this rule or this problem, is that you could be subject to different sets of rules for the same incident or same actions that you undertook. But the first point here to remember from the MPRE, and this should be a softball question if you get it, is if a lawyer is licensed in one state, commits a violation in another state, could the lawyer be subject to discipline in both states? Yes, that's very clear under this rule. Okay, here's B. Whose state law should apply? In any exercise of the disciplinary authority of this jurisdiction, the rules of professional conduct to be applied shall be as follows. 1. For conduct in connection with a matter pending before a tribunal, the rules of the jurisdiction in which the tribunal sits, unless the rules of the tribunal provide otherwise. Now, what do we mean here? This is a fancy way of saying if you go into another state to file a pro hoc vici appearance in a court to handle one matter that's before a court, and it could be litigation, this could be a probate matter or something like that, then if it's before the tribunal, then we will always, the ABA is saying, let's apply the rules of that tribunal, and that means that even your home state, in theory, the ABA wants them to apply the rules of the tribunal. But that's only for litigation matters. For everything else, it's the rules of the jurisdiction in which the lawyer's conduct occurred, or if the predominant effect of the conduct is in a different jurisdiction, the rules of that jurisdiction shall be applied to the conduct. In other words, the predominant effect wins over the location of the action. So I know it seems intuitively obvious that we should use the rules of where the act occurred, and normally we would do that unless the predominant effect is in a different jurisdiction. So let me give a quick example. You're admitted in the state of Texas, and you go to Oklahoma to handle a legal matter for one of your clients. Let's assume, for purposes of B, this isn't litigation. You're selling off a property, handling an estate, managing a trust or something like that, doing a deposition, closing a business deal, and so forth. If normally we would apply the rules of that state, unless you do something while you're in Oklahoma, the primary effect of which is back in Texas. Or you do something that the primary effect of which is in Kansas, for example. You could think back to your torts class about the person who is standing near the state border and shoots a gun and kills someone across the state line. So we can imagine a situation here where a lawyer does an action in one state that basically empties the bank account of a client or a third party in another state. Okay, B continues, this is B2. A lawyer shall not be subject to discipline if the lawyer's conduct conforms to the rules of a jurisdiction in which the lawyer reasonably believes the predominant effect of the lawyer's conduct will occur. This is basically a good faith safe harbor provision. In other words, we do have disagreements sometimes between states about rules. The most common area of disagreement between states is about advertising and solicitation, right? So there's a lot of state-by-state variation and a lot of deviation from the ABA's model rules on that issue. And so you could do something, run an ad or have a conversation with someone where you give them a flyer or brochure from your firm in one state where it's permissible and it's not permissible in another state. So obviously, this can be very confusing for you as a lawyer. How are you supposed to keep track of every state's complete ethics code? Well, it wasn't reasonable for you to think that what you were doing would primarily apply in one state, and you thought you were, and what you did, if you had been correct, would have been okay in that state. In other words, if you had a good faith belief as a lawyer that your conduct was predominantly going to have an effect in a state and you knew the rule in that state, but a tribunal later on disagrees with you, we will give you the benefit of the doubt about that. Okay, so I'm only going to hit a few of the comments here that I think could come up as test questions on the MPRE. So first, remember, the fact that a lawyer is subject to the disciplinary authority of this jurisdiction may be a factor in determining whether personal jurisdiction may be asserted over the lawyer for civil matters. And this is a maybe, but not always. Now, you may remember from my other videos, and they do ask this on the MPRE, the fact that you are held to have violated an ethical rule does not automatically mean you would be liable for malpractice. Right? They're different standards. It's different tests, different burdens of proof, different tribunals. One, you have to show causation for a tort claim or malpractice claim and damages, and for a ethical violation, you don't. And so don't assume that just because you commit a violation, you would also be liable for malpractice automatically. That's not true. And if you are liable for malpractice, that does not automatically mean that the state bar would discipline the lawyer. On the other hand, it could be relevant if the state bar is asserting a jurisdiction for disciplinary purposes for the courts to answer the simple question, the civil procedure question of personal jurisdiction. And so if you are subject to disciplinary authority, that at least weighs in favor. It's not the end of the matter, it's not automatic, but it weighs in favor of a court asserting personal jurisdiction in a subsequent or related civil matter. Okay, comment 2, and I think I've already kind of hinted at this or said this, a lawyer may potentially be subject to more than one set of rules for professional conduct. And if you don't get anything else out of this video, that's one of your big takeaways. So if you are licensed to practice in more than one jurisdiction and they have differing rules, and they all do, or you're admitted to practice before a particular court with its own particular rules. And so remember, if you're admitted in state court and federal court, there could be different rules. You could be sanctioned for something in federal court that you wouldn't have been sanctioned for in state court, and so forth. So if you hold a license in more than one state, and I think this is going to become more and more common now that we have the UBE, which makes it easy, or at least easier, for you to get licensed in multiple states, then you could be disciplined for any violation you commit in any state by every state where you are admitted. Keep that in mind. So let's say your place of residence is in Texas, your office is in Texas, most of your practice is in Texas, but you happen to hold a license in Illinois as well, or New Mexico as well. And then at some point you could, and you've never done a case in those other states, but you commit a violation here, those other states, all of the states where you are licensed, could subject you to discipline and could, in theory, apply their own rules. Okay, comment 5. I know I'm skipping, but I'm only hitting the ones that I think are really important to know for the test. So long as the lawyer's conduct conforms to the rules of a jurisdiction in which the lawyer reasonably believes the predominant effect will occur, the lawyer shall not be subject to discipline under this rule. Again, this is kind of restating the safe harbor provision when it's arguably, when reasonable minds could differ and it's really unclear which state's rules apply, then we will give the lawyer the benefit of the doubt for a reasonable belief. Okay, comment 5 continues, and this is a long sentence, I'm sorry. With respect to conflicts of interest, in determining a lawyer's reasonable belief under paragraph B2, a written agreement between the lawyer and the client that reasonably specifies a particular jurisdiction as within the scope of that paragraph may be considered if the agreement was obtained with the client's informed consent confirmed in the agreement. Lawyers, in other words, lawyers and clients can agree on which state's rules should apply to conflicts of interest. Why did they single out conflicts of interest? Because it's the murkiest area. We don't have a lot of state-by-state variation on the conflicts rules, not as much as, let's say, advertising and solicitation, but it is the area of the ethics rules that are the biggest minefield, where there's the most uncertainty about how much of a conflict is too much of a conflict, when do you have to get consent, when is a conflict non-consentable, and things like that. So if you've studied the conflicts rules, you know that there's a lot of unanswered questions or arguable points. And so what you can do with a client is have them sign a document, explain to them, the legal work you want me to do is going to involve multiple states or cross state lines. And so let's just agree that the conflicts rules, the law of conflicts of interest in Texas will apply. And if you've explained it and they've signed it and given consent, then we can apply Texas. Now, you can't just pick some random state and say, I'd like the ethics rules, the conflicts rules from Alaska or Hawaii, and you've never even been there and it has nothing to do with this representation. That's not a reasonable answer. But if you are doing legal work for a client that spans Oklahoma and Texas, or let's say New York and Connecticut, and they share a border, then you and the client could agree up front about which state's conflicts of interest rules should apply if there's a problem. And remember that conflicts can arise after the representation begins because of mergers and acquisitions between companies and things like that. So even if you've screened for conflicts thoroughly, after the representation is underway, you could have a subsequent conflict arise, and then it's very helpful to know which state's rules would apply. Okay, comment 6, promise we're almost done. If two admitting jurisdictions were to proceed against a lawyer for the same conduct, they should, in theory, applying this rule, identify the same governing ethics rules. In other words, the ABA would really like the states, if you're disciplined by more than one state, that you would be disciplined under the same set of rules for the same action. So they should take all appropriate steps to see that they do apply the same rule to the same conduct, and in all events should avoid proceeding against the lawyer on the basis of two inconsistent rules. Well, that's nice, but remember, the states aren't bound by the ABA. The ABA can't tell them what to do. So this is an aspirational goal by the ABA. It's the right answer about what a state bar should do for purposes of the MPRE, but what's going to happen in practice is really up to the state bar. Okay, comment 7 is the choice of law provision applies to lawyers engaged in transnational practice unless international law, treaties, or other agreements between competent regulatory authorities in the affected jurisdictions provide otherwise. And so, in other words, this choice of law provision under 8.5 also applies if you are doing things across international lines, unless there's some sort of treaty that is going to cover it instead. Here's a quick review question to see if you've been paying attention. An attorney has licenses to practice law in 3 different states. If the attorney violates a clear ethical duty to a client, which state may bring a disciplinary action against the attorney? A, the state where the attorney resides and has her primary office. B, the state where the violation occurred. Or C, all 3 states where the lawyer is admitted. Now, hopefully you know the answer to that. That was supposed to be an easy question, and if you don't, you weren't really paying attention and you should rewatch this video. Okay, that concludes our lecture about Model Rule 8.5.